Welcome back. Welcome back to Chapter 11. My name is Fawaz Bidawi, and Chapter 11 deals with legal authorities. So, if you're ever worried about that opportunity or that circumstance where you may find yourself having to explain to somebody where you got the authority to do what you did, here is the lesson for it, and we're going to be talking about what gives you the authority, all right, to do what you're doing. So we're first going to go, we first have to understand a few things that you are viewed as a citizen. You're not viewed as a peace officer, and we're going to go through the difference and how the law views you. However, there is a circumstance that is of concern, and that is Section 8 of the Charter, where everyone has a right to be secure against unreasonable search and seizures, and everyone has the right to not be arbitrarily detained or in prison. So this is the Charter of Freedoms of Rights. This is something that applies to peace officers or police officers. So a police officer is a type of peace officer. Why this is a concern is because in Section 9 of the in Section 9 of the Trespass to Property Act, if you make an arrest, it is deemed that the police have made the arrest, and therefore these charter rights will exist in that particular circumstance, in that event, okay? So you have to be very careful with that. That's why we put it into legal authorities part here. And remember, your legal authorities don't come from the Constitution. You have no constitutional right to have authorization. Authority means to be authorized to do something, to be given permission to do something, right? Legal permission. That's not the Constitution's job. The Constitution's job is to manage the government, but the government is, the federal government, the provincial government, municipal government. Now, at all three levels, you can, at a particular time, possess the authorization or authority to do stuff towards other people, like give them a ticket municipally, arrest them under the Trespass to Property Act, or that's provincially, and then or federally arrest them under the criminal code. So I did have to mention the Constitution because it will apply in certain circumstances, okay? Now we're going to look at Section 494. But before I go into the details of Section 494, what is a crime? Okay, what is a crime? A crime, it's not a provincial offense, it's a federal offense. Okay, not all federal offenses are crimes, but all crimes are federal offenses. And not all rules are crimes, but all crimes are rules. Okay, so so federal laws are viewed as laws that affect everybody in Canada. So if you decide to commit an assault, you're not committing the assault only against that person, but against that person and the rest of the country. And so the rest of the country, being the government, will be against you in that circumstance, and they will charge you. And if you ever go to court under a criminal offense, you will see the charge reading Regina versus and then your last name, and you might be wondering to yourself, who's Regina? Regina means the queen. Now it's the king, but ceremoniously we still use the reference of the queen in a lot of matters. So again, for acts that are completely prohibited, they must exist only in the criminal code. All other acts are restrictions. So provincial offenses are restrictions, okay? You're restricted, not completely prohibited. So a good example of that is the Highway Traffic Act. The Highway Traffic Act deals with laws on the road, but it is also the laws on the road are not only governed by the Highway Traffic Act, they're also governed by the Criminal Code. So if you are intoxicated, you will be um, you will be charged criminally, even though you were on the road. Okay, but if you speed, you can be charged provincially. If you reach a certain speed, an excessive speed, you may be charged criminally, because the one part is restrictive. What will happen if you go too fast? Provincially, you will lose the privilege of driving, so they can remove your right to drive for a while, and in some serious cases, indefinitely. Okay, I know of a person who got a lifetime ban of driving in Ontario. So I'm not too sure if the process was that he had to go to another province to get a driver's license, but uh, you know, I met that person and I talked to him, and he had a very interesting story, an unfortunate one, but interesting nonetheless. Um, Now, that's the restriction, but there is a prohibition. If you go over a certain amount of speed, an excessive speed, and you were charged criminally, that's prohibited. You'll more than lose your license, you might lose your freedom as well. Okay, so we're looking at the criminal code. Now, the criminal code is divided in about 28 parts, and then more than 850 sections. So when you look at a section of the criminal code, you will see, for example, section 494, and then they might have what's called a short title. Now, before I go more into details, what is the criminal code? So the criminal code, as I mentioned before, uh, is an aggregation of all criminal acts. So what that means is somebody has consolidated, somebody brought together all the criminal acts and into one document. Okay, because these acts were all created at different times within our government's history, and so they weren't that organized. And so a gentleman by the name of Bora Laskin decided to come into the picture and say, you know what, I'm going to sort and categorize all of these criminal laws, and we will revise them. So when you look at the criminal code, now we as civilians call it the criminal code, but the law calls it something else. The law calls it the Revised Statute of Canada, 1985, Chapter 46. So if I go into the Revised Statutes of Canada, that's somebody has, you know, a group of people have revised all the statutes and made them organized again. It's just like refiling a cabinet. I will have to go to 1985, uh, chapter C46, and we now have something called the criminal code. So we don't have to look in different years and different acts. It's all collected in one document, right? But these are the sections. So let me just go here. So these are all the parts, okay? Now the criminal code has a lot of, it's structured, okay? So there are laws that are offenses in the criminal code. There are sections that are completely offenses. They're laws, they're called charging laws, where somebody gets charged. But then you have procedural laws, okay? And you have those procedural laws can be authorization laws. What do you mean by authorization? Well, Section 494 is not a criminal act, it's a procedural law. Okay, so we're here in Section 494. And I'm just going to go to another document. So, Section 494 is it is giving somebody authorization to do something, okay? But we want to look a little bit deeper into the laws themselves. First of all, what is a crime? And a crime is an offense against the whole country. But there has to be two elements in the crime. There's the law violating act, actus reus, it is known in Latin, and then there's the mental intent to commit the act, because sometimes accident happens, but if you have the mental intent through your actions or omissions, then that is called mens rea. Okay, so if you have the act, mental intent equals the offense, and those two elements must exist. If you have the mental intent but you haven't acted, that might not be considered an offense. Now that is a little different when you're conspiring, because the conspiracy itself is the act, okay? So if you're telling somebody, hey, let's go and steal some TVs, the fact that it wasn't just in your mind, you were now planning, that is an act, okay? So, things to learn about the criminal code is something called issues in fact. Okay, the substance of the law identifies the fact and issues. The fact and issues is sorry, a collection of facts that require the existence before a judge can register a conviction on someone's criminal record. So only a judge can test the evidence in the trial and record a conviction. The section that deals with procedures directs courts to proceed by way of summary, indictable, or hybrid offenses. So what does that mean? Well, the criminal code is comprised of different parts, right? And in case you're confused, like what's the difference between a civil tort and a criminal code, we'll go real quickly. In a civil trial, a judge must decide on a balance of probability. So we mentioned that earlier on. If there's 51% chance that the person did it, then the judge will side with the side that has the heavier weight, right? The scales of justice, right? The balance is on their side, and so they're either acquitted or they're found at fault. But in criminal code, the judges must decide if the evidence is beyond reasonable doubt. So they have to be 99% sure. If they're 98% sure and there's a reasonable doubt, there's not enough to convict. So they could either stay the charges or they can acquit the person, right? The penalties in a civil trial is, while you're rewarding the victim for damages. But in criminal court, the penalties for the defendant is prison time. There might be some restitution. He might have to pay to restore the individual back to their original condition before you committed your act. So that's called restitution, right? In civil law, the lawyers represent each client, okay? But in criminal law, there's a private lawyer only for the defense. The government will hire a lawyer for the victim, okay? Because the victim doesn't need to hire, they're a victim, they don't need to hire a lawyer. And that lawyer that represents the victim is called the Crown, because as you know, we're a constitutional monarch, and again, R versus the person being accused, R being Regina, the person being accused is the defendant. So we have mental intent and we have the act. Now, there are three parts of every criminal code section. They sometimes are not together. So sometimes the penalty is separate from the section. It's in a separate section. And sometimes the penalty is connected to the section. But there's the substance part, and the substance part is trying to determine the mens rea and the actus reus. If if you do this and you had the intent to do that, then you have committed a crime. Then there is a procedural portion of the act, and that procedural portion of the section of the criminal code will indicate whether the act is indictable. So you know that the Crown is going to proceed by way of indictment in a trial, or is the act a summary offense? Okay, and sometimes the act is both. It's a hybrid. It's a hybrid offense, right? Uh, and so hybrid offense, what that means is the Crown, at their pleasure, under certain circumstances, can elect, can choose to actually pursue the matter by either indictment or summary conviction. Okay, so if, what the difference between the penalties and the standards are pretty substantial. So an indictable offense, I mean, in federal court, you could go to jail for up to 25 years. Where summary, not so much, but the standard is also much higher for indictment. So the Crown has to think, wow, if I go by summary, the standard's a little lower, I think I could win this case. But if the Crown goes by indictment, if they choose to go, oh, the standard's really high, I must make sure I have enough evidence to secure this conviction, or else I lose the whole case. And because of double jeopardy, once we try a person, we cannot, and we are not successful, we cannot retry them for the same crime again. So the Crown has to make a decision, and they have to be very confident with their case if they're pursuing a matter by way of indictment. So then you have the penalty portion. This is going to be telling the judge what the maximum penalty is. So this will show up on sentencing, okay? So the person's already been convicted. The verdict has found him guilty if it's a trial by jury. And now they have to sentence the person. What is the maximum sentence? Now, sentencing, the maximum sentence is very different than sentencing guidelines. So the judges have to look at a document to say, look, for these particular matters, this is what the average sentence is. And remember, this is a correctional system. If the person keeps on repeating the offense, the sentencing guideline will have a progressive disciplinary correctional correctional action, okay, to perform. So the judge has to say, okay, you stole once, you get 30 days in prison. You stole twice, you get 60 days in prison. You stole 5 times, you're going to get 2 years in prison, right? Because you're always before the courts. You're wasting everybody's time, and obviously you're not learning. So hopefully this time you'll learn, all right? Now, if a person has made it to 5 charges for the same thing, I can assure you it's more than a mental issue, mental health issue. It's probably a physiological issue. They might be dependent on some substances, or they might not completely understand the consequences of their action. Okay, because usually that type of pattern of behavior involves some type of illness. Okay, so we're looking at quasi-criminal offenses. Okay, these are provincial or municipal offenses are often called quasi-criminal laws, which are similar in nature to the criminal code offenses and usually have penalties that include fines or imprisonment. Okay, it can also mean the offense can proceed by way of indictment or summary conviction. I just want to make sure that we understand that crimes are Prohibitions means you cannot do them under any circumstance, and provincial offenses are restrictions. Okay? Section 494 is in the criminal code, but it's not a charging law. It's a procedural law, and it's a procedure to give you authorization. What does it give you authorization to do? It gives you the authorization to arrest a person who you've seen directly, find committing an offense. It gives you the authorization to arrest them, but there are some rules to that. So there are some conditions to that. Okay, so let's read section 494. Now, citizens and the police can use 494, but the police have something, another tool within the criminal code called section 495. We're not going to go into that, but you're free to go to this website here, which is justice.gc.ca. Look for the criminal code, and voila, you could read up on it yourself. So, anyone may arrest without warrant a person whom he finds committing an indictable offense, or a person who, on reasonable grounds, he believes has committed criminal offense. And so you cannot make an arrest based on reasonable probable grounds alone. Attached to subsection B is the word and. So he has committed an indictable offense, or has committed an indictable offense, and attached to it is escaping from and freshly pursued by a person who have lawful authority to arrest that person. So a person who has lawful authority, it could be other citizens. It could be other citizens that have made a hue and cry saying, hey, this person stole my bicycle, please stop him. Now you have lawful authority to arrest the person stealing the bicycle. The problem is, once you arrest that person, if the person who is in lawful possession of the bicycle then takes the bicycle and goes away, and you are left with the person you just arrested without any evidence they committed an offense, you will now be charged with an assault and forcible confinement, because you have no evidence to support your actions. Okay? When in doubt, let the law work it out. Call the police. Okay? As long as nobody's getting hurt, be the best witness for the police. This is what the description of the person is like, who I saw stealing. I saw them riding across the road, and I saw them doing a whole bunch of things. That's what it could be the circumstance. So there are marginal notes here. The owner, and this next section is very complicated for the courts to work out, because the courts want to be on the side of the good guys, but these are complications, and you could end up, if you don't apply the law properly, you could end up in trouble. Okay, so the owner or a person in lawful possession of property, or a person authorized by the owner or by a person in lawful possession of property. So the person holding the bicycle, okay, they're in lawful possession. They have what's called a color of right. So a color is the degree of right. So back in the day, they used to say they used to use the word color to really mean degree of right. So if you have a large degree of right to possess if you believe you have a large degree of right to possess the bicycle, right, or somebody has possession of the bicycle, so that person can, they make the arrest at the time that the offense is being committed, at the time that the bicycle is being stolen. They make the arrest within reasonable time. This will get you in trouble. Even if in half an hour you find your bicycle, you see your bicycle and you see the person, half an hour after it had been stolen, okay, you're driving around the neighborhood, you see your bike, and the person holding your bike, and you're sure that that's your bicycle, okay, after the offense is committed and they believe on reasonable grounds that it is not feasible in the circumstance for the police officer to make the arrest. So, I mean, they believe that if you call the police, they will take an hour to get there, and by that time, the bicycle is gone. You have a cell phone. You could call the police. You have a cell phone with most likely a camera on it. You could take a picture of the suspect. To apply this subsection is very risky. And as professionals, as security guards, we have to mitigate that risk. We have to mitigate means to lower the risk, okay? So anyone other than a peace officer who arrests a person without a warrant shall forthwith deliver to the police. Yes, of course. Why are you arresting a person? To punish them? That's unlawful detention. That's arbitrary detention, right? We are not allowed to detain people. Now, the word detention means they're being detained, right? It's misused. You first arrest somebody and then they're detained, right? They're remanded. They go to prison where it's a detention facility, right? So when you arrest somebody, you're obliged to get the police. You have to get the police involved. What happens if you don't get the police involved? And then you just release that person because you made a mistake. There's no mistake there. You intentionally assaulted a person and forcibly confined them. And so now they can call the police and they can say, hey, this crazy person arrested me, okay? Or this crazy person forcibly confined me. This crazy person assaulted me, okay? I am scared for my life. I don't know who this person is, and I'm scared they're going to do it again. I have a description of the person, and that would be you, okay? Even if you made a mistake, call the police, because you want the police to witness the condition of the person who's under arrest. Because if you release that person, and I know a lot of police departments, they will ask you to release the person over the phone. It is not recommended you do that because you need a witness to witness what condition that person is in when you release that person from an arrest, okay? Because they can go right to the police station and say, you touched my genitals. I was sexually assaulted by this person. What do I do when I make an arrest? Well, I call the police. And then as I call the police, I ask the police, the dispatcher over the phone, can I pass the phone to the person I just arrested? Strange, isn't it? But it works very well because what's happening on that phone is that phone call is being recorded. And so many times what will happen is the person will say, he arrested me because he thought I stole something. And they will ask them, do you need an ambulance? Are you okay? And they'll say, yes, I am okay. They can't go back after that and say, oh, I was under, duress. I was being threatened. Well, you were talking to the police. You, after the arrest, were given the opportunity to talk to the police over the phone, okay? And they are peace officers over the phone. And you didn't say anything about your treatment. You have to document your treatment. By the way, this happened to me before. I arrested somebody who then became a target by others, and they thought I wouldn't defend this person, even though the person I arrested did a very bad thing. It's my responsibility now because they're in my care, custody, and control. Okay? So when you arrest somebody, that's your responsibility. Okay? And it's a very, very serious thing because when you arrest somebody, they panic. Okay, and we'll go through that in the use of force. They're embarrassed, okay, because they never imagined that they'd be the bad guy or accused of being the bad guy. But sometimes things change, right? Now, Section 494 says you can make an arrest, but it doesn't say you could use force. What do you mean? says arrest here. Arrest doesn't mean force, okay? Arrest means I could stand in front of a doorway and tell somebody you can't leave until the police come. That's an arrest. I can tell somebody, hey, you're under arrest and the police are coming. So they're compelled out of fear to stay there. They don't want to leave, okay, because they're scared of getting into more trouble with the police, aggravating their circumstance, right? They don't want to leave. But 494 still doesn't give you the right to touch anybody. It just means you could arrest them. Section 25, and remember, Section 494 is authorization section of the criminal code. It's not an offense. There's no charge. You cannot lay a charge. You're being charged with Section 494. No, it's just procedure, okay? But there's a continuity to that procedure. And before Section 494, there's actually, way ahead, there's Section 25. Let's read Section 25. Just have to put it's Criminal Code of Canada. Okay, let's read Section 25. Okay, so we're looking at Section 25, and it says, protection of person acting under authority. Are we authority? Well, yes, we are authorized. That's what authority means. Are we law enforcement? No, we're not. Are we law administration? Yes, we are. We are law administration, and there's a big difference between enforcement and an administration of the law. Administration of law, you find committing, you can administer the law. Enforcement is you suspect somebody committed, you can detain them or arrest them for a little bit, and you can tell them, hey, I need to investigate you, okay? So temporary arrest, okay? Everyone who is required or authorized by law to do anything in the administration or enforcement of the law as a private person, as a peace officer or public officer, in aid of a peace officer or public officer, or by virtue of his or her office, is if he acts on reasonable grounds justified in doing what he is required or authorized to do, and in using as much force as necessary. This is the most important part, using much force as necessary for that purpose. So let's break this section down. Section 25. Okay, can you guys see that properly? Okay, section 25. Okay, so everyone, that means anybody. People working for the government, tourists, citizens, student permit holders, permanent residents, everyone who is required or authorized. So are we required? No, we're not required to arrest anybody. But law enforcement is, okay? If it's reasonable, yes, the police officer are required, okay? In many circumstances. We are not required. But what we are is, as security guards, we are authorized. Okay, so we are authorized by law to do anything in the administration. That's us. Anything in the administration or enforcement, not us. As a private person, are security guards private people? Are they? Absolutely. We are private citizens. We are not public servants. We are not officials. So official means they belong to the government, because official means that they're from an office, public office, right? As a peace officer or public officer, what do they mean by public officer? That could also mean the mayor. Remember, we went through that list on who is considered a peace officer. Okay? So public means they're being paid by the government. There's different types of peace officers. Police officer is one type of peace officer. Border agent is another type of peace officer. Court officer is another type of peace officer. That's why when you hit one of them, you get charged with uh, assault against peace officer. Assault peace officer, right? In aid of a peace officer or public officer. That could be us again. We could be in aid. Okay, we are a private person, but we could be in aid of them by virtue of his office. Again, somebody like the mayor. Okay, if he acts on reasonable grounds, so don't go overboard, is justified in doing what he is required or authorized to do, and using as much force as necessary. So you see an elderly person, they just exited the store without paying for the item. Do you do a fly tackle? Do you run up to that elderly person from behind and fly tackle them down? No, you could kill them, right? You could just use force by stepping in front of that private person. But what happens if you come up against a young man who it might be under the influence of drugs? Of course, we'll go into use of force and the dangers of using force. What happens if you come across somebody like that and they're very combative and stuff? You could use as much force as necessary, but that's where your discretion is important. You don't want to, if you think you're going to have to use less lethal force or lethal force, is it worth stopping the individual for maybe an item worth $10 or $15? No, if it means to jeopardize your legal position, absolutely not. Okay? Now it's saying that you can use as much force as necessary, but there is no threshold for as much force as necessary. So the next section is section is section 26 of the Criminal Code. Section 26 of the Criminal Code. And the title for section 26 is excessive force. There you go. Okay? You could see I'm a little bit OCD, obsessive compulsive disorder. Everything has to be perfect for me. Okay, hopefully you guys are guys and girls, and whatever the identity is. Don't want to exclude anybody. But I do really hope that you guys are learning something with this material that we are reviewing. So, back to excessive force. Okay, so we have, we are allowed to use force, as much force as necessary, but we have to put a ceiling on that force, okay? And that ceiling is in the form of section 26. So everyone who is authorized by law to use force is criminally responsible for any excess thereof, according to the nature and quality of the act that constitute the excess. Again, you can't fly tackle an elderly person. That's too much force. You can't use your baton to beat a 15-year-old into submission. That's too much force. If you think you're going to get into a big battle with somebody, when in doubt, let the law work it out. Call the police. In all circumstances, the police have to be called, but you do have some decision making to do. Should you apprehend this person and wait for the police, or should you rely solely on the police apprehending the person? The police are very busy. they get lots of calls. The police are very busy, they get lots of calls, and you might be on a very low priority because they figure, well, security's on the site. That being said, by the way, if you're a security guard and you do call the police, many times your call will actually be prioritized because you're a professional, and they, being a professional in this industry holds a lot of weight when you make that call. Okay. So another part of the criminal code here is a person under 12. Let me see if I could find this law. No, 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 no. No, 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 no. Okay. Child under 12. That's the law I was looking for. So, can you arrest somebody under the age of 12? Well, you got to ask yourself this. Again, no, you cannot. Why can't you arrest somebody under the age of 12? Why can't you arrest somebody under the age of 12? Well, because no person shall be convicted of an offense. So technically you can arrest them, but they won't be convicted of an offense. Now you're arresting them not for what you think. It is assumed that a child has no criminal intent, okay? Because they don't understand the consequences. They really don't understand what they're doing. So remember, between 12 and 17, it's the Youth Justice Act, but under 12, this is under 12, so that's 11 years old and under. By the way, 6-year-olds cannot be trespassed because they're 6, right? But if they're 11 and under, the parents are going to get in trouble, okay? Because they could be accused of child abandonment. Now, if you do come across a delinquent child and you see somebody contributing to that delinquency, maybe somebody telling them what to do, that's another issue. But if you arrest that child, they may be lost, and as a result of them being lost, they may feel that they have the freedom to do whatever they want. And we're not talking about 11-year-olds, we're talking about under 11 and under, right? Number one, don't take them in a private room. You're going to get in a world of trouble if you do that, okay? Keep them out in the public, keep them near you, and tell them you know their parents and you're going to call their parents, but you're really calling the police. Say, hey, look, there's a lost child in the mall. Has anybody reported a lost child? You know, my name is Faz Vidawi. I'm a security guard at Cedar Brae Mall or Fairview Mall or Scarborough Town Center or Eaton Center. Wherever you are, tell them where you are. You came across this child. The child's scared. Because the child is in need of immediate care and supervision. That's why you are arresting them. You're not arresting them for their crime or anything. They won't get convicted. I mean, they might go to trial. I doubt it. But who will be suffering financial consequences for their action will most definitely be the parent. Okay. So we're going to look at, now we understand a lot about arrests, and I've made hundreds of arrests in my now 25 years in the security industry. I no longer make arrest, what I do is I review, as the chief investigator of Canada Guard Security, what I do is I just review the cases. I want to make sure that we have enough to convict, that the guard had made the right decision to make that arrest, and that we are complying with any demands from the police or the courts, okay? And I'm also the person who sets policies. So even though the law allows you to make arrests, I set the policy in what circumstance an arrest can make. And preferably, if you're in a metropolis like Toronto, just call the police, don't make the arrest. Now, if a serious crime has occurred and you witness them committing that crime, and you think it's for the safety of yourself and others that that person not continue to offend, then yes, under those circumstances, we would permit you. The security company you are working for will have their own arrest procedures, okay? And most security companies forbid arrests. It is also client dictated directive. It is also a client dictated directive on whether they want arrests to be made on their property, because the client is vicariously liable. Even though you made the arrest, there's no legal insulation between you, the contractor, and the client, because the client hired you. So not only is your security company in jeopardy for any lawsuits as a result of a wrongful arrest or an arrest involving excessive force, okay? Because you could have had a good arrest, but you could be accused of using excessive force, okay? The clients can say, under no circumstance can you make an arrest, okay? Now, what you do off a company hours in your own time, nobody can dictate that. But again, it's much better to be a good witness than a bad arrester, okay? So, we have on many occasions made arrests, especially as investigators, and I could tell you a story once. We had received information that there was fraudulent use of a credit card, and we had gone to the retail store to try to retrieve some video evidence of the person who perpetrated it, because we didn't have a description of the person who committed the fraud until we went to that store, and they did voluntarily give us the information. Upon reviewing the information, getting a description, we got another call that another fraudulent transaction had occurred, but now in the same mall, and now we had a description. So we were actively pursuing this individual. We were looking for this individual, and we came across this individual. We were plainclothes. We had we were undercover essentially. It wasn't our intention, but unfortunately, security wasn't around for us to get them involved. They were in the mall, but we didn't notice them. Otherwise, what we usually do is we approach security. We tell them, look, we're investigators. We show them our ID. We're going to be looking for this particular person, and upon discovery, we will be making an arrest. So we end up finding out that it was a 17-year-old girl. Okay, so it's a young offender, and we approached this young lady and described to her that we'd like to talk to her. The matter does involve the purchases she just made with the device she just used, and she just stood there in absolute shock. And I said to myself, I don't think this is gonna go well. I think she's panicking. And a malicious person is, I could tell you, is a calculated person, which means they are less dangerous than a person who is panicking. A person who's panicking is very dangerous. Now, we had made the decision to arrest her, but we didn't want to do it out in the public because we didn't want to tarnish the experience of other shoppers. We also didn't want to intentionally embarrass her because she might voluntarily give us information about the source of this device. She could be a potential cooperating witness. And so you don't want to burn those bridges with the mall and and with your potential witness, okay? Um, but as soon as I asked her to follow me with my partner behind me, uh, she she started to display resistance. Okay. Long story short, it took me, my partner, and two security guards, and we were trying our very best to put the handcuffs on her. It was a terrible scene in this mall. Okay. Um, but and I was injured as a result because I'm a larger person than this 17-year-old female, and so I am very restricted on how much force. We cannot use our elbows or our fists. We can only use pressure point control tactics, and because she was experiencing such an excess of panic, okay, uh, that they were not effective at all at any of my strategies. She was crying, she was screaming, and I didn't want to be in that situation. I didn't want that to happen. I did want to make an arrest, but I didn't want the arrest to go that way. And so that's something to consider when you decide, hey, I'm going to make my first arrest. Understand that the majority of arrests go bad. Okay, that means there's going to be violence. Majority of them. Okay, and so eventually the police that were stationed at the mall also attended and assisted us. At this point, she is injured. She needs to go to the hospital. She is injured herself. And there was a lot of paperwork and legal fees as a result of the whole interaction. We had to get lawyers. They're not cheap. We had to answer to an investigation. The mall was at the point of trespassing us. So that means I couldn't even do my job at that mall again. There was so much negative outcome as a result of that decision. Okay. Um, but that was part of our job. It was the virtue of our job. And we did our best to avoid that situation. But sometimes you just can't avoid it. And so again, that was me as a private investigator. Now, if you're a security guard and you don't have any equipment, you don't have any use of force training, and you have to make a decision where you want to arrest somebody, you could make that decision to arrest somebody, but to use force is a separate decision. Okay, and that's what section 25 and 26 is all about. Yes, section 494 says you can restrict the mobility of the person. That's what an arrest is. You're restricting the mobility because you want to present this person to a judge. Why are we arresting people? To give them to the police so they can be presented to a judge. But it's a completely separate decision, and remember that, to use force. Okay? Section 494. Remember that section. It has different subsections in it. It is not a charging law. It does have a substance, but it is a procedural law that is critically important. You will be tested on this on the ministry's test. You will be tested on this in the most important place to be tested, which is the interview room. Okay, you're going to be in the interview chair. You're going to look dead straight at the recruiter, okay, the HR recruiter. They're going to ask you questions to see if you qualify. People have driver's licenses all the time and still don't know how to drive. Unfortunately, in this industry, a lot of people have security guard licenses, man, they still don't know what they're doing. Okay, so we're gonna go. So that is the lesson for section 494. Now, when it comes to more details on the use of force, okay, which is section 26 and 13, it will be in the later chapter for the use of force. Thank you so much for the opportunity to allow me to review the citizen's arrest or anyone's arrest procedure within this chapter. We are going to be going to another video. Please stay tuned for the other video on another element of this chapter. Okay? If you have any questions again, please email. Don't hesitate to email us. See you in the next video.